Let's see. This story is from CBS News, but I think, all these news stories tend to be the same because they all follow each other's. They're basically copying each other. Let's see. They have video of the woman being arrested. So they did a perp walk on Facebook. That's always nice. Thanks, Sheriff. The sheriff said this was not a stand your ground case, but simply a killing. Well, certainly not a stand your ground case. May have just been simply a killing. Of course, not all killings are unlawful. The sheriff says, now many of you were struggling to understand why there was not an immediate arrest. The laws here in the state of Florida are clear. I may not like them. I may not agree with them, but those are the laws I will follow. Again, sheriffs are also elected positions. So he's a politician, Sheriff Woods. Most of these facts, let's see, are the same. We've already covered. Owens approached the homeowner's house, knocked on the door multiple times, demanded that the homeowner come outside. Larynx then fired one shot through the door. This is not simply a knocking on the door. Deputies responding to a trespassing call at the apartment Friday. So that would not obviously have been the shooting reporting trespassing. The only person who would have been trespassing would be her. She's not calling to report herself as trespassing. That would have been the homeowner calling the police. Why don't they say that? The sheriff's office knows who made the trespassing call to the police. When questioned by the sheriff's office, the homeowner claimed she acted in self-defense and that Owens was trying to break down her door. The homeowner also claimed that Owens had come after her in the past and had previously attacked her. Highly relevant claims, folks. Highly relevant evidence. May not be true. I don't know. I'd have to see the actual evidence. But these are the right questions. Was there an apparent attempt to break down the homeowner's door? Were there previous attacks by Owens on the homeowner? Those are the right questions. The manslaughter charge the homeowner is facing is punishable by up to 30 years in prison. She's also charged with culpable negligence, battery, 2 counts of assault. Then we have the civil rights attorney, Benjamin Crump, who's representing Owens' family, said in a statement that the shooter had been yelling racial slurs at the children before the confrontation. He also represented Trayvon Martin's family in 2012, in which he lied relentlessly and unashamedly about that case, and still does to this day. The sheriff's office hasn't confirmed that there were slurs uttered or said whether race was a factor in the shooting. So I guess the evidence isn't uncontrovertible, is it, Ben? Let's see. Woods said on Monday that detectives were working with the state attorney's office and had to investigate possible self-defense claims before they could move forward with any possible criminal charges. Obviously, they've done that now, and I think that's a good policy. Let's see. Lauren Smith, who lives across the street from where the shooting happened, said the homeowner was angry all the time with the children. Well, we know the mother was angry, right? The woman shot. We know she was angry at the moment of the confrontation. Or at least there's evidence to support that. The sheriff said since January 2021, deputies responded to at least a half dozen calls in connection with the feuding between Owens and the homeowner. Who made those calls? There was a lot of aggressiveness from both of them back and forth, whether it be banging on the doors, banging on the walls, and the threats being made. And then at that moment is when Miss Owens was shot through the door. Again, are we to believe the homeowner was banging on her own doors and walls? We know there's evidence that the woman shot was demanding the homeowner come outside. Why? To have a pleasant conversation? I'm heartbroken, said moms demand action. We've seen this again and again across the country. It's really because of lax gun laws and a culture of shoot first. Of course, that's just anti-gun propaganda, anti-civil rights propaganda, anti-Second Amendment propaganda. This woman with the hyphenated name, executive director of Moms Demand Action, said stand your ground cases, which she refers to as shoot first laws, are deemed justifiable 5 times more frequently when a white shooter kills a black victim. That's just a lie. That's an outright lie. Whenever I ask these people for data to support that claim, they either don't provide it or the data they provide are not stand your ground cases. They're just shootings involving people of disparate race. They may be shootings that involve self-defense immunity hearings, but those are not stand your ground cases. And in any case, just because statistical variation doesn't mean it's an injustice. For example, almost 60% of violent crime in America is committed by the 5% of the population that is young black men. There's a disparity for you. In 2017, Florida lawmakers updated the state's self-defense statute to shift the burden of proof from a person claiming self-defense to prosecutors. This means authorities have to rule out self-defense before bringing charges. Okay, this is just a hot mess of wrong information. Probably not deliberately wrong, but journalists tend to be pretty stupid people. They're just getting it wrong. So the burden of proof on self-defense has always been on the state in Florida. It's on the state in every state now. Ohio was the last holdout that put the burden of proof on self-defense on the defendants. But once you're at trial, the burden of proof on self-defense is on the state to disprove self-defense beyond a reasonable doubt, period. Now, before the trial, if someone charged with a use of force crime is seeking self-defense immunity, demands a pre-trial self-defense immunity hearing, there, the burden of proof in Florida used to be on the defense to prove self-defense in that hearing, to get immunity by a preponderance of the evidence. But in 2017, the Florida legislature said, no, we don't like how this is working, because nobody was being granted immunity by these hearing judges. The Florida legislature said, no, the way the trial judges, the hearing judges are dealing with these cases, no one's getting immunity. That makes the self-defense immunity statute meaningless. So we're going to change the burden of proof on self-defense immunity, not self-defense at trial, which was already on the state to disprove self-defense beyond a reasonable doubt. We're going to put the burden on the pre-trial self-defense immunity hearing, also on the state, by clear and convincing evidence, which is evidence that's more than a preponderance, but less than beyond a reasonable doubt. So that shift did occur. When they say that means authorities have to rule out self-defense before bringing charges, that was already the law before this shift in burden happened in 2017. Before the change in law, prosecutors could charge someone with a shooting, and then defense attorneys would have to present an affirmative defense for why their client shouldn't be convicted. Why should this be the standard? If it's a clear case of self-defense, shouldn't the cops have to at least consider the possibility that it was self-defense before they run this person's life through the gears of the criminal justice system? Just consider it. Take a look. Could it have been self-defense? That person shouldn't be arrested and required to hire an attorney at great expense to raise a legal defense. The article continues. In fact, stand your ground and castle doctrine cases, which allow residents to defend themselves either by law or court precedent when threatened, has sparked outrage amid a spate of shootings across the country. Well, outrage is that just means propaganda, right? That's Benjamin Crump. He's looking to get another big paycheck. All stand your ground and castle doctrine do is relieve you of that element of avoidance, relieve you of an otherwise existing legal duty to retreat. This phrase is so weird, but this is the kind of mental incapacity of most journalists, which allow residents to defend themselves either by law or court precedent. Court precedent is law. Law comes in two forms, right? Statutes by the legislature, and then when those statutes are interpreted and applied by appellate courts, those appellate courts establish precedent. That's just as valid law as the statute. And what difference does it make whether the law outlining your privilege to use force in self-defense comes from statute or comes from precedent, appellate court decisions? Most states have self-defense statutes, defense of other statutes, defense of dwelling statutes, all that. Some states don't. Massachusetts has no self-defense statutes except for castle doctrine. But Massachusetts self-defense law is entirely in precedent, entirely in appellate court decisions. That doesn't make it less valid than if it were in statute. Then they talk about the Ralph Yarl shooting, not really relevant here. Missouri and Florida are among about 30 states that have stand your ground laws. 39 states, folks. 39 states are stand your ground states, either by statute or by precedent. The most well-known examples of the stand your ground argument came up in the trial of George Zimmerman, who fatally shot Trayvon Martin. Was stand your ground ever argued in the George Zimmerman trial? No, not in any form. Not in the proper application of stand your ground, whether or not there was a legal duty to retreat. There was no legal duty to retreat. Anyway, in the Zimmerman case, he'd been struck to the ground. Trayvon Martin was mounted atop him, beating him into the sidewalk, per eyewitness testimony. You're undergoing the imminent deadly force attack. There is no chance of retreating when you've been pinned to the ground. There is no safe avenue of retreat. And if there's no safe avenue of retreat, there is no legal duty to retreat, even in a state that's a duty to retreat state. Even in those states, the Massachusetts, the Maryland, you're only required to retreat. You only have that legal duty if it's possible to do so with complete safety. If you're pinned to the ground and getting your head beat into a sidewalk, there's no opportunity to retreat with complete safety. So Zimmerman would have had no legal duty to retreat on the facts of that case. And therefore, there's no role for stand your ground to relieve him of a legal duty he doesn't have. Now, of course, often journalists and others misuse the phrase stand your ground to actually mean self-defense immunity. That's an error. That's sloppy thinking, sloppy labeling, leads to confusion. But let's pretend that's what they mean here. Did Zimmerman ever pursue self-defense immunity? No, that never happened either. So there's no form in which the Zimmerman case involved stand your ground at all. Why do people believe it did? Because of Benjamin Crump's propaganda campaign. Before trial, Zimmerman's attorneys chose not to pursue a stand your ground claim. They mean a self-defense immunity claim, which could have resulted in the dismissal of murder charges, as well as immunity from prosecution. Those are the same things. If you're immunized from prosecution, the charges go away. But during the trial, the law was essentially used as part of his self-defense argument. No, it wasn't. No, it wasn't. His self-defense argument was straight up self-defense. Had nothing to do with either stand your ground or self-defense immunity. I watched every minute of that trial, and neither of his lawyers, Don West nor Mark O'Mara, ever made reference to stand your ground or self-defense immunity in any substantive way. They may have said something along the lines of, the judge will instruct you that stand your ground doesn't play a role in this case. They certainly never argued it on behalf of their client.